Okay, good morning. This is Senate Natural Resources and Energy, and it is Friday, January 30th. Huzzah. And we are starting with, well, we're starting a number of new bills this morning, and to kick us off, we are given a new draft of S212. And so we have our legislative council here with us. Welcome.
Good morning, this is Michael Grady, Dutch Council. As the chair just referenced, you should have a new draft of this one. Yep. It's the first draft of an amendment you've seen, but it has a 4.1 draft on it because the chair directed me to work with the agency to meet some of the concerns that the agency was raising, and the fact that they're already in a process regarding redoing connections or redoing authorizations for connections. And so what's in front of you reflects the conversations with the agency, and hopefully it meets your intent.
Thank you.
So I'll just move through. It's still amending the chapter of law related to potable water supply and wastewater system connection. The first section is the purpose section, and the bill is introduced. The purpose had been about delegating to municipalities the authority to do connections, but there's still going to be a component of delegation here, but not full delegation like there had been in prior authorizations. So the purpose is changing, and it's not about delegation, it's about to allow review of potable water supply and wastewater system connections pursuant to general permits issued under the chapter. And then you move to the definitions. In the definition of potable water supply, there's a.
Before we move on, I just want to make sure I'm understanding what that section is doing. So this is where maybe it's obvious, but this is allowing to adopt a general permit regarding.
No, this is just a purpose section.
Oh,
purpose sections are really just expressions of legislative intent. They can be helpful to a court when looking at what you intended to do if there's litigation.
Yeah.
So it's intended there to be clear that you're allowing general permits for connections, and then you will get to the express authorization later.
Thank you.
So on page 2, you're in the definition of the potable water supply. There was a slight change recommended by the agency. It had previously said this definition includes a service connection to a public water system of any size. That does not require a permit under Chapter 56, and that's already in the last sentence of that subdivision. So the agency just recommended shortening the sentence that's on line 6 and 7. They did not explain that.
So that sentence was redundant to the last sentence.
The last phrase of that sentence that in the bill is introduced had that reference to does not include a potable water supply that is subject to regulation in Chapter 56. The agency pointed out, well, that's already in there. You don't need that twice. On page 3, you're moving into section 3. This is the permit section. I want to point out a couple of things that are existing law and that are not changing, but that are relevant to the discussion. The first is on page 3, line 9 and 10. Making a new or modified connection to a new or existing potable water supply or wastewater system requires a permit underneath this chapter, and that's why you were here, what this bill is about. I also want to point out on page 3, lines 12 and 13, the statute already says that the secretary shall give deference to a certification by a licensed designer with respect to engineering designer judgment exercised by the designer in order to minimize agency review of certified designs. But keep that in mind. We're going to come back to that in a minute. The statute already says the agency gives deference to licensed designers. But before we get to where that is relevant, the bill continues to strike full delegation to municipalities. And so part of that is striking the language on page 3, line 19, 21, going on page 4. That was the delegation for connections in designated downtowns with no real other criteria. And so that's being struck. And then on page 4, you get line 13, you get to the language about agency's authority to adopt a general permit. So the secretary shall adopt a general permit for potable water supply and wastewater system connections that require a permit under the chapter. Under the general permit, secretary may give deference. Remember, we just talked about how statute already allows them to give deference. Secretary may give deference to applications for connections certified by a designer listed under the chapter. And the secretary shall also publish a manual providing guidance to licensed designers implementing the general permit. And the manual shall include standards for determining or defining the capacity of a public water system or pollution abatement facility for purposes of approving that connection. So that's the specific general permit. That's what the agency was working for when the bill was introduced. They wanted to go to a general permit. It's going to be for all connections, not just for those delegated connections. And it's going to rely on deference to the designer as statute already allows.
Yes.
Maybe you're about to get to it, but on page 5, secretary may adopt general permits for other activities.
Right, because there's a long list of actual permits that are needed under this chapter. You just required one for connections, and now you're giving the secretary discretionary authority to adopt general permits for the other types of permits.
Other types of permits, what's encompassed within that?
Here's one. Whenever you subdivide land, you're supposed to get a permit under this chapter for the identification of a wastewater and potable water supply for the subdivided land. So is it possible to have a general permit for that? I'm not the technical expert on it, but that's a category I could see potentially them using a general permit.
Okay, and you want to, because we were talking initially about the connection, general permit, and I just want to make sure I understand if we're going from this to this.
Well, you haven't yet gone to this. You've said if you want to go to a general permit for this type of permit, you can do it. This is not unusual, this type of discretionary permitting authority. For example, in the water discharge section, there's a statement in there that says the General Assembly authorizes the Secretary of Natural Resources to use general permits to the fullest extent to implement the Clean Water Act. Okay. And so that's your decision though. If you want to give that discretionary authority, that's your decision.
Okay, just want to make sure we're actually doing.
Yep. Yes, question.
So I noticed that one from the change was from the secretary will give deference to May.
Yes, for this program, and to an extent, I think that's probably it's probably wise, because if you're talking about a significant scope construction with potentially significant numbers of connections, you may not, the agency may want to look at that more closely rather than give deference. This retains their oversight, that their ability to have oversight. And I think that's wise when you're talking about something that can really affect public health and the environment when it's not done correctly. Moving, should I move on?
Yes, well, I think I have a question as well. This section that we're talking about under K is this is where we're giving them authority to make this general permit that they were intending to do with when since last year, basically. Okay, I'm just making sure following what's happening.
So you're actually directing them
To do it. It's not just authority, it's like do this thing.
You do that.
Okay, yeah,
And then, as Senator Bongard pointed out, there's also discretionary authority. General permits for other
right,
types of requirements.
okay, thank you.
On page 5, line 5, section 4, this is that section in existing law about delegation of the permitting authority. You're first striking out that full delegation authority, like Colchester, Charlotte, they previously had received full delegation and they surrendered it because they didn't want it's anymore. And so there's no other town with full delegation, and like we know they're going to fully want this. But I think you heard testimony, I believe it was from Burlington, that they might be interested in partial delegation of connections. Especially if they have the ability to review them. And so this retains that partial delegation on the bottom of page 6, not on page 7, where the secretary may delegate to a municipality authority to conduct that technical review of proposed projects that include both municipal potable water supply and wastewater system connections, provided that the municipality actually has control over the service lines. You don't want to give them connection authority as something that they don't have. For example, there might be a fire district within a municipality that provides water under service lines. And that, the larger municipality, fire districts are municipal, the larger municipality can't get delegated to do the connections in that fire district because they don't control those service lines. The municipalities delegated shall be required to incorporate the requirements of the general permit. So you don't have a municipality that's been delegated that has its own different set of standards for connections. They have to incorporate the requirements of the general permit adopted by the agency. And that will include deference to certifications provided by licensed designers. Now, if a municipality submits a request for delegation, the secretary shall delegate, but only if certain conditions are met. First, they have to be qualified to perform the technical review. They have to have someone either on staff or whom they hire that will be able to do the technical review. They need to receive authorization by the municipal body. So your public works department can't just go out rogue looking for this. It has to meet any other requirement for delegation by the secretary in writing. They will only issue permits for those service lines that they control and when there's adequate capacity in the system. So that is where, going back to the manual that the secretary is directed to adopt, where the secretary is directed to determine or define what is adequate capacity. That's where partially this will come into play. That will come into play.
One question about this. So this with partial delegation here. If the municipality wanted this, received it, would they have the capacity to charge for those permits? Or do we need to give them authority to do that?
we're gonna get to that.
Oh, okay, never mind,
We're
yeah.
gonna get to that.
Okay.
But one of the things that came up as part of the discussion about partial delegation was the state would like to track those authorizations.
Mhm.
It's important, especially for real estate attorneys, land use attorneys, to know what permits attach to a property when required. And you'll see on page 8, 9, 4, and 5 that the municipality that's delegated, when they approve a connection, they have to submit documentation of the permitted project to the secretary. And we'll get to a little bit of nuance on that in the section in a second as well. So that's the permit section. That is the authorization for the general permit, how the general permit will provide deference, how the secretary will adopt a manual to provide instruction on those connections. It also provides for delegation, partial delegation. And so there's your current general permit and partial delegation. And then you go to section 5, you're moving out of title 10, you're moving into title 3. Title 3, section 2822 is A&R's fee section. It's a monster. And one of the subsections in it talks about when a municipality is subject to a permit fee and when it is not, and whether or not it can charge a fee for when it is doing its own permit review. And you are adding on page 9, line 9 through 14, that municipalities that conduct the technical review or approval of a potable water supply or wastewater system connection permitted under that permit section within the municipality may charge a fee for the cost of municipal services, provided that the municipality shall also pay that administrative processing fee of $100 for submission to A&R of documentation of the municipally permitted project. So they get delegated, they're approving, they can charge their fee. They have to, when they send in documentation to A&R, they send $100 filing fee. Which, let's be realistic, the municipality is going to charge the applicant when the applicant applies for the municipal authorization.
Right. And I guess I would just say it makes, I can argue both ways in terms of like, are we just silent on how much that fee can be or the cap on that? Or say, you know, should be no more than to try to like limit that. But my instinct is to not specify, but do you have thoughts?
I did not put in a specific amount because I've heard that different municipalities charge very different fees for those connections. And that they can be potentially a tool for municipal development decisions effectively.
Question?
So how you, in our said $100, so how do you change that to?
Well, no, this is just the filing fee. This is just when the municipality approves the permit, they're sending the fee that the document of permit approval to A&R. A&R is probably going to figure out a way to incorporate that into their permitting, their electronic permitting system. And they need some money to figure out how to do that. And so that's what that is.
Yes.
So anything that, if municipalities aren't doing this now, aggregating the dough, getting the authority back, or anything that makes us think they're gonna be more likely to do it. So,
If they aren't doing it now, this definitely gives them authority to do it, which technically they didn't have a lot of authority to do anyway. The will they be more willing to do it? Yes. Will more want to do it? I don't know. This is something that if the general permit is working smoothly, It's gonna cut down on the administrative review. It's gonna make it easier for development to develop, while maintaining the same standards for connection, and you have the licensed designer who is responsible for that. I think that it might be easier for a municipality to go with the general permit. But that will take some time to implement.
So just to follow up, this section that we're talking about. Making it clear that municipalities can charge this fee, is that? For any municipality that is doing technical review work, or is this section just for those municipalities that receive partial delegation?
It's when they are authorizing the permit, so it's really only for those that have delegated authority.
Okay, so it's not, and right now we think Burlington may be interested in that, we're not sure. There's others, so this is still relatively narrow.
It's still relatively narrow, but
Who might be taking that?
right.
Yeah.
But say you're a municipality that charges $5,000 for a connection as your way of as a tool in your toolbox to drive where development is. You may want to get partially delegated to retain that tool in your toolbox.
It's making me wonder about allowing municipalities who are doing this anyway, just making it very clear that they have the authority to charge for that. But that's not this section. I just want to, I want to think about that a little bit.
Okay.
Thank you.
And then the other change in this section is actually setting the permit fee for those general permit authorizations, which would be on page 11. So projects permitted under the new general permit will be $500. Flat fee.
Sorry, what line was that?
Page 11, lines 9 through.
Oh, I see, thank you.
I do have a question, and it might be something I should have talked to the agency about. Are there potentially connections that won't be eligible under the general permit that will need an individual permit? And then do they need to have a permit fee that's based on flow? I don't know. It just kind of dawned on me this morning when I was reviewing. It's not in here right now.
Mr. Redmond is here, would you like to comment on that question?
For the record, Brian Redmond, it's a good question. We haven't gone through the process of distinguishing what connections may be so technically complex that they would require an individual permit. I think the intent is to have the connections go under the general permit. But we could do a quick analysis of that and make recommendations.
Okay, so putting a pin in that. Sounds good, thank you.
Okay, that's all I've got a pin in whether we should have these two categories. These. So have that discussion
Sure.
from simple to complex, kind of odd, it's all $5. So
Sure.
And then you come to the second to last section, which is about implementation. So the agency is going to need some time to put the general permit together, hire who they need to help put that together, and put together the manual. So on or before December 1, 2027, they publish the general permit and the manual, and beginning on January 1, 2028, we begin accepting certifications of connections under the general permit. So it's about a year and a half.
And since Mr. Redmond is here, can I ask you a question? That feels like a reasonable timeline to you.
It does, we are expecting between 8 and 12 months for the work under the design manual to occur, and that's the first thing that really needs to be completed, and then from there. We would be working to stand up the documentation for the general permit, putting the general permit on public notice, creating all the materials around that. As well as the transmittal for system for the partially delegated municipalities to get us the information. So I would like to say earlier, but everything always takes longer. So.
Sure, no, fair enough, and. You were still standing this program up anyway, so it's not like you weren't already doing issuing permits under a general permit, it was still under design,
In
so,
development.
okay. Great, thank you.
Should I move on?
Yes, I think we're good to go on.
So in the department's wastewater system and potable water supply rules, there are multiple subsections or sections related to either connections or delegation that will no longer be relevant once the general permit is enacted. And so there are two exemptions, subdivision 1-3-4-15 and 16 about modification of design flows for wastewater systems with potable water supply connections. They would go away, they're gonna be consumed by the general permit. And then there are there's an entire section in the rules related to delegation of municipalities. Some of those subsections will remain, because remember, there's still partial delegation. But some of them are about full delegation. And so anything that's related to full delegation specifically is repealed. And then there may be other references in the water supply rules related to full delegation. It's on page 12, line 11 through 15, I put in like a kind of a disclaimer that any references in the rules related to full delegation no longer applicable or enforceable to the repeal of statutory authority for full delegation.
Sorry, just to, I think you just said this, but I want to make sure that I'm taking some good notes on this, so, well, actually, it's right there, so lines 4 through 6. Well, so they all refer to what is being repealed, exactly, like in those notes there.
Yeah, everything from
all-
4 through 10 are specific subdivisions in the rules that would be repealed. Because 4 through 6 will be consumed by what's the general permit.
Okay.
And then 7 through 10, because you no longer have full delegation authority. And there's no longer any municipality with full delegation. And then 11 through 15. There are references to delegation in the rules, but aren't specific enough. I would have to like do a line by line amendment. And I don't know if you really want to do that.
Yeah.
It could be a lot,
Be a much longer bill.
well, not much longer, but it would be longer. So this is just saying that references to full delegation aren't applicable or enforceable. And when the agency amends their rules the next time around, they can be the ones that go through and get rid of those
Okay.
references.
Well, it's just as a matter of, like how you go about it, it's just interesting, I guess, it's interesting to just say these rules shall be repealed on this date as opposed to the line by line, but it's, and then making that an effective date of, January 1st, 2028. But I guess, so either way, it accomplishes the same thing. Okay.
Yeah.
That's fair.
I mean, full delegation is the specific full delegation authority is being repealed.
Right. And
So the other references to it
Right.
technically aren't applicable anymore anyway, but just want to be clear.
Mhm. So when, just in terms of like how that happens, So we get to 28 and then yourself or as recommended by the department, they would then go line by line to be like, okay, I'm taking this out, I'm taking that out.
Well, the next time they redo their rules, the next time they go to an amendment in their rules.
Okay,
Um,
that's when it would actually come out.
yeah,
But then if they don't do that until like 29 or 30, and then there's just pieces lingering that
this,
are ineffective.
right,
Oh, okay.
and this is still law.
Mhm.
Even though it's session law, it is still law, it will
Okay.
still be something that the agency can rely on and say those references are not
Okay,
applicable or enforced.
that was also part of my question. So this section 6 is session law, but the rest of it is not.
Correct,
Okay,
you need the effective date of session law, but
sure. Okay, I want to make sure that I'm understanding.
the rest of it,
Of it.
the rest of it amends the chapter and law related, either it amends the chapter law related to potable water supply and wastewater system permits, or it amends the A&R permit fee section.
Mhm.
So to statutory provisions.
Mhm. And I'm zooming out for a second, but just to be clear, the thing that we're aside from the partial delegation, with the general permit, the thing that we're fixing there is that they might have had authority to adopt a general permit for municipal potable water supplies, water and wastewater, but not for general. Not, what's the right phrase? Like the septic systems.
Oh, yes, right, so they do have general permit authority for indirect discharge.
Oh, for indirect discharge, that's the phrase.
10 VSA chapter 47. There's no specific general permit authority in this chapter. You are directing them to adopt a general permit as the method of providing for administrative efficiency for permitting connections.
Mhm.
And you are also specifically giving them that general permit authority
Mhm.
for other permits underneath this chapter.
Mhm.
So there won't be an argument that whether or not they have general permit authority or not.
They have it.
They have.
That will clarify,
Yeah.
they have that. They have the authority and we're telling them to. Okay. Super. Questions about this? It seems like we're getting closer with this. There was some discussion about whether or not we should require them to figure out a definition for capacity. And that's something I think we can talk more about, but would love to start thinking about winding up this bill. Yes.
The directive to them to adopt the manual requires them to determine or define what is adequate capacity. So it will be in the manual in this draft. If you want it in another way, I really think that's the discussion.
Did we call that out specifically in this draft that the manual shall include?
Yeah,
Okay, I think I missed that. Okay, great. So as long as that is in there, so they will be coming up with a definition of.
it says on page 4, line 19, 20, going on to page 5. The manual shall include standards for determining or defining
Oh, there it is.
the capacity of the public water system, et cetera.
Great. Okay. So there's still a couple of items in here that I think that are worth discussing, right? So the fees, we have 2 categories and
Whether or not they should have individual permit authority for certain connections.
yes. Perhaps we can either have a discussion or get some further testimony on that, and I think we're good to go with that.
Guess I wanted to bring a little more, just don't have my apartment, but it runs around. All the other sections and what that actually translates to. Just want to make sure that I know all this stuff.
So,
Also, some key examples of what we're also giving general permit authority for what to include. This is what I've been thinking about connections, and now it's, well, to be honest, I want to make sure I know what we're doing.
yep, I think that's
Yeah.
fair. So perhaps we can have Mr. Redmond in sometime, not gonna be next week.
Tuesday.
Tuesday, oh, Tuesday,
Already.
oh, amazing. And is this something that you could address at that point? That would be very helpful. And if you have any thoughts on these other couple of questions that we've raised about fees and then complex permitting situations. Okay, fabulous. Thank you so much. Very grateful. Okay, so we are gonna move on to a new bill, S 247. Which is a bill about, largely speaking, it's about plastics. I think of this bill as having 3 different parts. You can hang out,
Okay.
that's fine. So, and we're just walking through this bill, so they will take testimony on it later on, but generally speaking, the 3 different parts, the first part is about the use, I would frame it as the use of plastic material as feedstock into pyrolysis type processes. People might call this chemical recycling of plastics. You might also hear it called advanced recycling. That's another phrase for it. But I just from my perspective, on the one hand, I think pyrolysis that might be useful for me to just say a little bit about that. My understanding, anyway, pyrolysis is it is bringing material up to a very, very high temperature in the absence of oxygen. And so as a result, it like starts to break down. And one of the concerns is that as it breaks down, it gasifies, you can get some really exotic chemicals coming out of that process. And is that something that we want in Vermont? Do we want to be putting these kind of chemicals out into the world? Especially as they might break down in a variety of different ways. Now, we can take some testimony on that, but that roughly speaking, my understanding. So this bill would prohibit the building of chemical recycling processes with plastic as the feedstock in Vermont. So that's part 1, or the first chunk in my head. The second is about there's a type of plastic, DEHP, that is sometimes used in the plastics in certain kinds of medical devices. So in like IV bags, that kind of thing. And then as they age, they break down and the plastics end up leaching into the material, basically getting into people's bodies, which is not great. And even more largely speaking, as they get thrown out, leaching into the environment. So you end up with this plastic breaking down into microplastics into the environment. Again, not great. And as I understand it, there's some sufficient alternatives so that we think we need to use this. If there's a sufficient alternative, then let's not, depend on a material that is doing this kind of harm. And then the third part of this is about prohibiting microbeads or microplastics, and we can have that conversation, microbeads, microplastics, having that kind of plastic in personal care products, and wanting to, again, as much as we can, get microplastics out of the environment, like prevent it from getting into the environment in the first place, prevent the it coming into our ecosystem, largely speaking. So, that is part of the idea there. I mean, the part of the issue with all of this is that we know that microplastics or plastics in general break down into very small parts, especially as they age, and then they're very hard to get rid of after that, and they become sort of ubiquitous in the environment. And that's something I think we would all like to avoid. I think we've all heard the stories about the amount of plastic that we end up consuming, that ends up in our brains, that ends up in the different organs. And again, if we can prevent that from happening, yeah, exactly, right? Like how do we reduce the input of microplastics into the environment? So, having said all of that, we'll walk through this bill, the Legislative Council. Thank you. I will turn it over to you.
Well, again, it's Michael Gray, Legislative Council. I think the chair did a good job of defining the three components of this bill. First is about chemical conversion technology and what may be allowed, or not. The second is about the use of that phthalate DEHP in medical devices and medical containers. And the third is about the use of plastic microbeads in personal care products and cleaning products. I do have a couple of questions for you for this bill as we go along. I'll point them out for you. I think they're just really largely questions about enforcement and how you want to enforce the second and third components of the bill. So beginning with the first component on page 2, section 1. This is about the use of plastic in certain types of technologies that can be used either to create other types of chemicals or can be used for fuel. Generally, the burning of waste in Vermont is prohibited. This isn't considered, this type of technology isn't necessarily considering the burning of waste because the component, the input, the feedstock is not being discarded, it's being used for something else. And what you're proposing here is to prohibit those types of feedstock inputs, et cetera, uses because of the potential harm that they may cause. So the big definition that's relevant is what is chemical conversion technology. It's using plastic inputs as a fuel or fuel substitute for the general use of plastic in energy production, or its use in the following processes. Gasification, that's conversion of biomass or inputs to gas. Pyrolysis, the chair just described what that is. Solvolysis is using chemical solvents input for its intended purpose. Hydropyrolysis is the use of hydrogen for the chemical breakdown. Methanolysis is the use of methanol for breakdown. Glycolysis is using the breakdown of glucose. Enzymatic breakdown is protein catalyst used to for the breakdown, and solvent-based purification is the selective solvent for dissolution of the input. Combustion is tuitive, and then any other process used to transform plastic or plastic derived materials into monomers, waxes, lubricants, feedstocks, crude oil, diesel, gasoline, or the facilities is if you're going to be using these inputs, generally A&R has to permit that facility, and that is what that definition of facility is. It's one operated for the purpose of performing facility, aiding or otherwise engaging in chemical conversion. Plastic is the general definition we use for plastic, synthetic material made from linking monomers through a chemical reaction. Create a polymer chain that can be molded or extruded at high heat in various forms that retain their defined shapes, etc. Recycling, you might not need the term recycling here unless you're going to add something later on. I'm going to point that out. So then you get the prohibition, page 3, lines 13 and 14. Persons shall not use or operate chemical conversion technologies in the state all of those processes using plastic as a plastic input, they would be prohibited. So that's why that definition of chemical conversion technologies is integral to this component of the bill, because those are the things that will be prohibited. And then a person shall not build or construct or operate a facility in the state that uses chemical conversion technology. So even if AR has permitted one of those facilities, that facility no longer can operate. And the prohibition in the subsection applies to the modification or conversion of any existing certified solid waste facility in the state into a facility that uses a chemical conversion technology. So you can use a solid waste facility that's processing and then convert it into a chemical conversion facility. Now, this is where I think recycling comes in. I think this is where you make a decision. Are you banning chemical conversion technologies for recycling? The term recycling is not used, honestly, in this component, and will it include recycling or does it not include recycling? I think you want to probably talk to the advocates or the agency about that. And if you want to be clear if recycling is something that is allowed to use these technologies or is also prohibited from using this technology.
Thanks for flagging that. You can ask that question.
And then the state shall not provide grants, subsidies, etc., other financial or incentives to support development of facilities that use chemical conversion technologies or programs focused on chemical conversion technologies. Now that is a prohibition. You don't see any violations, you don't see any penalties, you don't see any appeal. And that's because this is in Title 10. And the solid waste chapter is enforceable under ANR's general enforcement authority. It's appealable under ANR's general appeals authority. You don't need to reference any of that. The agency has the ability to set default penalties under that chapter. So that's why enforceability isn't referenced. It's not that it's not there, it's just inherent in the program itself. Moving on into the second component of the bill, this is gonna ban that type of phthalate, the DEHP, the diethyl hexyl phthalate, from use in medical devices and medical solution containers and medical tubing. So you will see what intentionally added DEHP is, something that the manufacturer added to an intravenous or other specified medical solution container or medical tubing product, and that has a functional or technical effect in the product. Medical solution container is things that are used to house medicine, fluid, or nutrition therapy, administered intravenously or through the mouth, nose, etc. Medical tubing is tubing used to administer fluids, medication, etc. It includes IV tubing for I'm not going to say this right. Parenteral nutrition, and that's nutrition that without the use of the digestive system, so intravenously, and it also includes it for enteral nutrition, and that uses the digestive system, feeding tubes, nose feeding tubes, etc. And it also includes respiratory tubing and nasal cannulas delivering oxygen. But this is a question, it says just to an infant or a child. Is it just to an infant or a child? Should it just be for everyone? I'm not sure. So that's a question for you.
Teenagers excluded.
But,
They can
you know,
decide.
maybe they.
Yeah, right. That's a fair point.
So page 5,
So-
word 5.
Wait, before we go, you were referencing line 18, is that right?
No, it would, for the cannulas for the infant or the child, that's
Yeah,
page 5, line 1 and 2.
okay, because
So,
Oh, I see, cause there's also page 4,
but that
And
says
18.
adult, child or infant, adult, child or infant. But then the cannulas is just an infant or a child.
as I'm just reading, like reading this again now, it's occurring to me that like. That feels like it's covering everyone, can we just say everyone?
Right.
And then for page 5, line 2, should it be everyone?
Right.
Yep.
There's a definition of unintentionally added DEHP intravenous. It's when the phthalate gets into the medical solution container or medical tubing, when it's not intentionally added for that functional or technical effect, you're gonna potentially have de minimis byproduct that winds up in these products. And then beginning January 1, 2030, no person shall manufacture, sell, or distribute in commerce in Vermont a medical solution container made with intentionally added DEHP. And then beginning January 1, 2035, no person shall manufacture, sell, or distribute in commerce in Vermont medical tubing made with intentionally added DEHP. And no person replaces DEHP prohibited in a product under the section with other orthophthalates. And a medical solution container or tubing product shall not have unintentionally added DEHP present in a quantity at or above 21% body weight. So there is some byproduct that's allowed, but not more than 0.1% body weight. And then there are exemptions on page 6. Human blood collection and storage bags are exempt, and uresis and cell therapy blood kits and bags, including integral tubing, are also exempt.
And before we move on, this section here. Starting on page 5, where line 8, so no one shall distribute in commerce. Medical solution container made with DHP, and then the next part, no person shall manufacture, sell, or distribute commerce with tubing into the essentially added DHP. Can you describe the difference between B and C?
So B is for that type of product that's a medical solution container.
Okay, it's just.
And C is for the medical tubing. So you have 2 different effective dates for the two different products. It is duplicative. I probably could have done it in a way where the duplicative language has been combined, but.
Sure, well, and the other thing, I just wanna make sure, so that this is, I'm thinking about the plastic bag ban and how we allow people to like. Use the stock that they
Oh,
had,
sure. This doesn't have an inventory exception, but. The other alternative to inventory exceptions are long run up effective dates, and you have a
Yeah.
long run
Yes.
effective date here.
Right.
So they can plan for it,
okay,
but that's a very good one.
anyway, speaking out loud, I think we're good to move on, thank you.
All right, but. This is where the question of enforcement comes in, right? So like that first section of conversion, which is in A&R's authority, this is in the Department of Health's authority, and the Department of Health has default penalties too. They're $50 to $100 as a default penalty. What other sections in this chapter do is it provides the ability for a person or the Attorney General to bring an enforcement action as a consumer fraud violation. And then for an injured person to bring their own private right of action. So for example, the tanning facilities prohibition, let me use another one. The bisphenol A one says violation of the section shall be deemed a violation of the Consumer Protection Act. The Attorney General has the same authority to make rules, conduct civil investigations, and bring civil actions, and private parties have the same rights and remedies as provided under 90 chapter 63, which is where the private action is. Do you want that type of authority here, or do you want to rely on the Department of Health general penalty, or do you want to create your own penalty specific to these prohibitions?
Do you want
I think the answer is yes. We want the broader report that you were just talking about. And that of course depends on, obviously, we're gonna hear from the medical society, and everybody else about whether it's actually workable out, but assuming it is, then if we're gonna do it, it has to mean something. Okay?
Mhm.
So moving on into the third component of the bill, which also has that same question about enforcement. I'm not gonna bring that enforcement issue up again. If you want to enforce this as a consumer products violation, you want to probably apply it to section 1515 as well. And so this section prohibits the use of certain products or prohibits the sale of certain products containing plastic microbeads. And you will see all of the kind of components of the main definitions. There's air care product, automotive product, chemically formulated consumer product, and designated cleaning product, and general cleaning product. So I'm gonna skip over them for the purpose of time. Well, basically, it's when there's a plastic microbead that's included in these products. I do want to point out on page 8, the definition of personal care product. It's an article intended to be rubbed, poured, sprinkled, or sprayed on, introduced to, or otherwise applied to the human body or any part thereof for cleansing, beautifying, promoting attractiveness, etc. I point that out because there's already a federal law. It's called the Microbead Free Waters Act of 2015 that prohibits certain rinse-off personal care products from having plastic microbeads in them. And that law has a limited preemption clause in it. It says no state or political division of a state may directly or indirectly establish under any authority or continue in effect restrictions with respect to the manufacture, introduction, or delivery for introduction into interstate commerce of rinse-off cosmetics containing plastic microbeads. Cosmetics are personal care products. Soap, most soap that you use is a personal care product. Most of you never ever use soap. Because soap is basically just lard, and that's how, and some lye. That's basically how the FDA defines soap. Most of us don't use soap. Most of us are using a personal care product that's technically a cosmetic.
I'm just imagining saying that on the floor to a bunch of vendors.
So,
Yeah.
yeah, you don't use soap here.
Letting you all know, we all sit too close together.
So can I ask a question about that?
Sorry, but
So if the federal law preempts state law in this area, it only preempts it for soap, or does it preempt it for personal care products?
It preempts it for anything that's rinse off personal care products. But I think you have a really easy way to deal with that. You just add a provision in here that says something along the lines of that these requirements don't apply to the products that are preempted, or these requirements shall be interpreted to apply the same requirements for under federal law. And you know, you just say we're going to comply with the preemption clause in the Rinse Off Products Act, and you then still get to regulate it, but you have to manage those products in compliance with the, because you're going to get advocates that are going to come in here and tell you that this bill is preempted. And I want to tell you that there's a way that you can get around that. And that's
And you will help us do
what
it.
I do.
Yeah. Awesome.
okay. Important information.
So on page 8, line 13 through 19, beginning January 1, 2029, a person shall sell, offer for sale, distribute, or offer for promotional purposes in the state A personal care product containing plastic microbeads that are used as an abrasive clean, exfoliate or polish, and a rinse off or non-rinse off product including chemical paste and sunscreen. Or a designated cleaning product containing plastic microbeads that are used as an abrasive, clean, exfoliate or polish. The act takes effect on July 1, 2027, but there are effective dates built into the provisions of that.
Okay. So more to come on this bill, but we are otherwise done with this issue for today, and we will come back to this another time. Lots to talk about in here. Any thoughts before we keep going? Go ahead.
Was really important. Thanks for then. I think you're looking at to do is just test all of the provisions to make sure that actually work.
Yeah.
And to the extent they are, ready to go.
Okay,
Yeah.
Okay.
So it's forward.
Yep. I agree.
Have a good weekend.
Yes, you too.
Thanks, Michael.
Okay, so with that, I think we are ready to move on and
You ready for?
yes, we are. He was just in here.
Okay.
Maybe we'll take a short break until Senator
Relax.
Like,
I do that on several driveways, first few times.
There we go.
One way to get us to stop talking about it.
I used to do, why don't we just do that, we give us all together.
So, this is Senate Natural Resources and Energy coming back from a break, and we are joined by Senator Mathis. Welcome. We got a bill S-299,
Yes,
and it's about posting.
it is.
Yes, take it away.
Yeah, so for the record, Senator Chris Mattos, Chittenden North District. Had some folks in my area reach out about land posting. And how every year they own land and some bigger tracts that they recreate on and whatnot. And going around every single year, having to write down the date to make it be effective for the following year. Can be challenging, especially for older Vermonters that are around the area, and some of these folks that reached out to me will help out their neighbors and do that same sort of thing, but. There was an incident where a couple of the signs came down, bumping up against the edge of that year, and it was during the hunting season, and they ran into poaching issues. So being able to, this bill wouldn't change anything, like if the signs are gone, they have to be maintained anyway. But just extending that timeline out 5 years, so they don't have to walk up to every single sign, change the date, update the date, but they still have to maintain them, so. They have to make their rounds, quite frequently, but they don't have to walk all the way up to that tree or post and write down the date to make it be in effect. And then another piece is just, at the time of, exchanging of property. You have to disclose that your land is posted, just so that if the next person is buying them, I know they'd have to register, but. Just so if the next person's buying, the signs aren't standing up if they don't want them up, and if they know, or if they don't know, I would. Feel they would know because they're every 400 feet, but if it's not a state buyer, they may or may not know, so just having that knowledge there, and if. The next person doesn't wanna have it be posted, they know right up front. So that's just kind of the basis of the bill. I know there's been a lot more about posting land this year, than I was ever expecting. I put this bill request in, but, that's kind of the thought process I have with the constituents in my area.
Super. Thank you so much. Any questions for Senator Mathis?
No.
Excellent.
Wait, I do have a question.
There was no question.
Yeah, I just,
Senator Hardy.
I just liked it, your company, so I want you to
Thank
stay a
you.
little longer. The disclosure, is this a disclosure like? In the real estate transaction, when
Yeah.
you're closing on a house, you have to disclose, or do you put it in the? So it's when you put it up for sale or when you're closing, which is,
Either or, so just, in real estate right now, a lot of times there'll be a seller property information report. The realtors put out ask you 7 pages of questions about your property.
yeah,
I can envision a little box on there that says, is your land posted?
got it, okay.
Keep in mind, those don't go along with every transaction, my experience is being a realtor. If somebody's never lived on the property, I don't have them do a seller's property information report because you can be held liable for what's ever on there. And due to that nature, there's a lot of don't knows, because if you truly don't know something on one of those disclosures, you shouldn't guess yes or no. But somewhere along the way in the contract, it should be disclosed. I mean, we disclose on lead-based paint if it's built before 1978. That was my thought process on that.
Got it, okay, thanks.
Question?
Isn't there a possibility that ironically it backfire because you're actually putting in the minds of the out-of-state buyer and posting it up? Maybe better off saying nothing about posting, but hope it doesn't occur to them.
I always would rather disclose more than not. This would be
But
open.
it's actually not posted anymore if they buy it, because that your sign is no longer valid.
Right, but if the signs are still up, people are still gonna say,
Yeah.
me personally, I was brought up, if I see a posted sign, I don't care about what the date says or if it's signed or whatever. I understand the intention of that landowner to not go on their property. It was also instilled in my parents, don't go on somebody's else's property without asking for permission. I found out
that the hard way from my father when I went across somebody else's lawn, but, yeah, that's kind of my thought process there, like, if somebody wanted to. If they didn't know there was posted signs out there, be able to go out there and retrieve those.
Question,
I know a lot of it has to do with the material that the poster is made of.
Yeah.
Some are paper, some are plastic.
Yeah.
But even when you take a plastic poster using indelible ink.
Mhm.
2 years when the date is gone, so. Typically 5 years from now, if I had my land posted. And it wasn't an issue, I probably didn't go out and post it.
Yeah.
Well, refresh the posters, so.
Yeah, in my travels, I've seen land posting signs, they'll print it, their information, put that on the land posting, and then they'll actually, not shrink wrap, but
laminate.
laminate, thank you. Laminate sign to try and combat that. But
Thank you.
that's the gist of the bill.
Okay, super, thank you so much.
Yeah.
All right, and we will invite legislative council up to join us, welcome. And I think this is your first time in this committee, if I'm not mistaken.
Yes, it's my first
Yes.
time meeting, it's also my first time meeting Senator Matthews. And so my interaction with many of you so far has just been virtual, so it's nice to see you in person.
And tell us your name again.
My name is Bradley Showman, Office of Legislative Counsel.
Should we introduce ourselves?
Sure, let's introduce ourselves.
Bradley, it's nice to meet you. I'm Senator Ruth Hardy.
Nice to meet you.
Nice to meet you.
I'm Secretary Wayne.
Nice to meet you, nice to meet you, great, great.
Dan Watson.
So, all of our, for the Bennington district, Scott,
Great. Nice to see you again. Okay, so I have the bill in front of me, and it looks like it's the preference of the committee to look at the bills here, so I'm gonna put it up on the screen unless there's a request to do that. And so the purpose of Senate Bill 299 is to amend the requirements for posting of land against hunting, fishing, and to change the posting requirement from annually to once every 5 years. And this bill would also require that a seller disclose that the property is posted at the time of transfer. So let me give some background on the legal issue here. So posting of land in the Vermont Constitution, hunters had the right to hunt on property. That take liberty in seasonal times to hunt and fowl on the lands held on other lands that are not and held on other lands that are not enclosed. And so what that means is that hunters can hunt on lands in the state of Vermont unless that private property is enclosed. And so by statute, what the state has done is define what enclosing the property actually means. And so what enclosing actually means as a matter of law is defined in 10 BSA 5201, which is the language here. I will also note, as some more background, that some clerks have raised this as an issue because the Department of Fish and Wildlife has indicated that posting annually means posting once every calendar year. So if you post on November 1st, your posting will expire 2 months later on January 1st. You have to go out and post again. And this is, to my knowledge, and I've looked on the Department's Fish and Wildlife's website, the Secretary of State's website. To my knowledge, that this is not a formal rule yet, but it is a directive that clerks are getting from the Department of Fish and Wildlife. And so this might be a proposal that will be pending through the rulemaking process. But to my understanding, as I've seen it so far, it is not a formal rule, but it is information that the clerks have received. And so this bill would change that, and let's go to the length of the bill to see how it comes up with a solution here. So the first page, we're down on line 16 and 17, and owners have the right to post their land. On the next page, and owners can post their land against shooting, trapping, or taking of game, fishing, or taking of fish. And then or all three or a combination thereof, fishing, hunting, trapping, or taking of game. So property owners can prohibit or permit those activities. And they can also post by permission only to permit those activities as well. As Senator Manos explained, that the notices must be legible and maintained at all times of the year. But this is where we're making a change. They shall be dated every 5 years or after a change in land ownership. So this is line 13 and 14 on page 2. Line 16 of section C on page 2. This changes the posting requirement from annually to every 5 years in the town clerk's office. Or requiring that the posting be recorded in the town clerk's office every 5 years. And then we add some clarifying language saying the posting shall be valid and enforceable for 5 years after the date the posting is recorded. And so it makes the recording dates the operative dates to determine when the 5 years runs, as opposed to in the statute as it is written, it just says annually, which could be up to interpretation of whether that means a calendar year or 365 days after your birthday. So there's some ambiguity in the statutes. And this line in lines 18 and 19 is meant to make it clear that the operative date is the date of reporting.
Okay, so can I ask?
Yes, yes.
So just if I recorded my land posting on September 15th of 2025, then as long as I maintain the signs, it would be posted until September 15th of 2030.
Yes,
And then I would have to do it again.
that's correct.
Okay,
The recording would have to be done again.
yes, okay,
And just to be clear, because legibility is important and notice is important for hunters, but it isn't that requirement to maintain the posting to make it legible is throughout that 5 years.
right. Can't read it, you don't know what it means.
Exactly.
I wanna come back to this question, but this is maybe too detail oriented, but it's making me wonder about. So if we start on September 15th, does it go to September 15th inclusive of that day? Or does it go to midnight of September 14th?
This is like a.
It is like this, I can't wait. What's the second?
I think typically how we count days, it would go until you're covered on 11:59 on September 14th. And at midnight on September 15th, you are not covered. And so you'd have to get your posting in essentially on the 14th.
Okay, I just wanted to be clear about that. So that September 15th of the following, of 5 years later.
Yeah,
You're not covered if you haven't renewed it.
that should be correct, yes. Yeah.
Okay, all right, thank you.
And the idea is to also give landowners flexibility of when would be convenient for them to post, right? Because when you do have to record, you have to put the new date on according to Department of Fish and Wildlife regulations. And so you would have to replace all of your postings with the new date at that time. And so if you did it in September when it's warm, you're not necessarily having to go out and trudge in the snow. And so it gives property owners that flexibility, and that's the goal of the statute here. Or excuse me, the goal of the proposed amendment here, proposed change to the statute here. Any more questions on the posting piece? I can move on to the reporting, the property transfer piece. Okay.
Well, I don't know if you know this. It's more money issue, but the $5 fee, do you know how long that's been in statute? Like, when was the last time anyone looked at that?
It has not been updated in at least since 2013.
Okay,
Yeah.
not bonsai, but.
But I don't know a date. I suspect it's been much longer than that.
Okay.
And so that hasn't been looked at.
Town clerks, yes.
No, it's like. Adjusting for inflation, it's $500.
Exactly. 1963.
And so the disclosure of information and posting of land, Vermont, just some background here, Vermont, many states have, maybe a standard form by statutes of real estate disclosures that have to happen. Vermont doesn't necessarily, it does not have a standard form by law requiring certain disclosures, but it does have certain disclosures requirements in the law. As Senator Maddow said, lead paint when the building is older than 1978, I believe it is. And so there isn't a particular form that we would be amending there. It's just we would be adding to a statute or adding to certain disclosures. And this would be one of them. So we would add a new section in the statute requiring that prior to or as part of a contract for conveyance of real property, the seller shall notify the buyer whether the property is posted pursuant to 10 VSA section 5201. So it's a requirement as the contract or prior to the contract of sale of some kind of notification. And then we added this section because it is in the subchapter in which this proposed addition lives, its marketability of title, and so we added here that non-compliance with the requirements of the section should not affect the marketability of the title of the property. And just to add that piece in there, so it is required disclosure, but wouldn't necessarily affect the marketability of the title if that disclosure is not made. And the effective date of this bill would be July 1st, 2026, as proposed here.
Great, yes.
I notice there's no prohibition against trespassing in that. Title 10, is there another statute that covers just regular posting against trespassing?
Yeah, there is, and it's 13 ESA 3705, that's a criminal statute for trespass. And a landowner is required to either give actual notice to say don't trespass or post no trespassing signs. Those signs are less particularized to hunting, fishing, or trapping. And the key piece with that is that the difference here is that an individual has a constitutional right to hunt in Vermont on someone else's private property unless the private property is enclosed. And so the no trespass sign in and of itself, arguably, does not prohibit someone from hunting on someone else's land because of that constitutional right to hunt. And so enclosing the property is a particularized activity, and that's why it's its own section in the Department of Fish and Wildlife statute.
So is Fish and Wildlife required to respond if somebody is trespassing on the property?
Feasibly, they would. Feasibly, someone would have to report or investigate a violation of this trespassing permit. How that is taken care of, whether Fish and Wildlife contracts with local law enforcement, or whether it's their own wardens who go out to do the enforcing, I think would be a great question for the department to testify about those resources that they do to enforce these no trespass, to make these prohibition on hunting.
So they're required to post every year too against trespassing?
On public lands? I'm not.
No,
Not on
any
public.
private land. If they're posted, do they have to register with town clerk? It's just against trespass.
Just because there is no requirement in that statute to register the trespass only with the clerk. And so the clerk registration is unique to this piece.
So if I'm a property owner and my property is posted against trespassing, and I call a game warden, does he have to respond to, because it doesn't have to do with hunting, fishing, or trapping?
No, trespass, that would be a criminal statute. And so that would most likely fall onto the responsibility of local law enforcement to enforce the trespass. So the no trespass generally is a criminal statute in 13 VSA 3705. This is a civil statute in 10 VSA.
So punishable as a misdemeanor, or?
It is punishable as I'm not sure if it's a misdemeanor or a felony, but it's almost certainly not a felony. But it's punishable by $500 fine or imprisonment of up to 3 months, but not both.
Good, thank you.
Okay.
Super not gonna tackle that here,
Any-
that was so traditionary.
And that is a much broader issue.
Yeah.
And this piece deals with the constitutional issue, the constitutional right in section 2, or excuse me, chapter 2, section 67, where it gives hunters the right to hunt on private property, and it gives landowners the right to enclose that property. And so this statute kind of puts that provision of the Constitution into effect.
So, not to belabor the point, but if I'm trespassing, I just happen to be hunting and fishing, still trespassing.
I think that is an interesting issue that a landowner might have to litigate. Because if something is posted against trespass, you feasibly could contact local law enforcement. And if the individual who is trespassing asserts, I'm not trespassing, I actually have the constitutional right to hunt and fish here, and I don't see that the land is enclosed in accordance to the law, that could be a legal issue that is litigated in the courts. And I will explain to the committee, this is probably way too in the weeds, but
No, but this is
I
interesting.
found it interesting.
Tweets.
So there is a Vermont Supreme Court case that deals with the statute in a footnote, so it's dicta, it is not binding precedent. But the issue in that case was, whether, it did not concern posting land against hunting, it concerned posting of land, to prevent, to make it private property, right? To prevent police officers from entering without warrants. So let's just bracket that piece off. So it did not concern hunting, more broadly. But one of the issues was that raised in the case was that, okay, so this property is not posted against trespass, or excuse me, against hunting, fishing, and trapping pursuant to this statute. And so it should be the case that police officers can come into the land without warrants. And the Supreme Court in a footnote said, that's the wrong issue. We're not even looking at that. One is open fields, constitutional rights, and search and seizures. This doesn't touch that. But in the footnote, they said that, okay, well, just because the landowner didn't comply with the statute doesn't mean that the land is not enclosed pursuant to their constitutional rights to enclose the property. And so essentially what the Supreme Court is saying is just because you don't record, just because you don't post, doesn't necessarily mean that you have not effectively enclosed your land against hunting. And so that's interesting. It's an interesting wrinkle. And so Senator Williams, when you bring up that issue, you know, if there's a no trespassing sign, but someone says they're there for hunting, I think that that would be a needy issue for the Supreme Court to take up, and it would be a big question mark on how they would decide that.
I think more than that is that a lot of people, what they post against no trespassing, they do it on the roadside, and they don't do the backside of the property, so if a hunter happens to come into their property, they can be arrested or cited for trespassing, they didn't even know it was posted.
And this statute does, the statute as it is right now does require that notices prohibiting the taking of game shall be erected upon or near the boundaries of the lands, and effective notices at each corner, and not over 400 feet apart along the boundaries thereof. And so if they just post on one boundary, but maybe not the others, it might not be effective for enclosing. And those are sticky individual issues that might lead to litigation, or might lead to a property owner not being able to enforce what they thought that they could enforce. But the statute does anticipate enclosing, perhaps with, or it does envision using with notices throughout the boundaries.
Okay, thank you. Also, I really enjoy your enthusiasm for the dicta there. That was, you know, like, well, getting in the weeds, it's great.
Very good.
So thank you. Super. And so we're switching topics one more time. One more witness for the day.
Thank you.
Thank you.
Yeah, my pleasure.
So we're moving to Mr. Davidson from Summit Properties, who was not able to join us the other day when we had our housing updates, and he was able to join us today. So thank you so much for being here.
Yeah, good morning, everybody. Yes, I realize I missed Housing Day in your committee, and that this is the last piece of testimony on a Friday on the day that you didn't have the rest of the testimony. So I hope this can be open and maybe more question oriented than presentation oriented. But Jude, I don't know. I prepared a few slides that I didn't get sent in. Am I able to share those?
Not unless you send them to me.
Okay, I didn't know if I was able to share them myself, but that's okay. I will send them to you right now.
Let me be the co-host.
Is that okay with everybody? We can
Oh,
do
yes,
that
yes, we're
also.
gonna give you that
Yeah,
power.
we're all set now.
Okay, well, thank you. Well, I'll do the introduction. For the record, Zeke Davison, Summit Properties. We're one of the state's largest developers of affordable housing. We do maybe more true mixed income development than any other developer in the state, pairing affordable phases with market rate phases and workforce housing. We have been operating in Vermont for since the 70s. We were one of the first low-income housing tax credit developers in the state. We manage about 1,300 units. Most of those have some affordability restriction on them. All over the state, Chittenden County, Addison County, St. Johnsbury, Rutland. And so we see, a lot of the property management occupancy issues, but we are active on the development side. I think, when Jude invited me, I think you were, between Kathy Byer and Jonah, and I don't know if you heard from Jonah on Wednesday, but looking for sort of a perspective of a larger scale by Vermont standards developer and affordable housing developer. I've been in to testify for the last 3 sessions, and so forgive me if I forget what came through in the Home Act and what was Act 181 and what was I don't know if it was 47 the year before that. But I think the thing that most of my testimony has revolved around over the last 2 or 3 years is a project we're doing in Middlebury, because it's a large project. It's outside of Chittenden County, and that's sort of a bit of a unicorn for many decades in the state of Vermont. I will share this slide and walk you just through a little bit about that. And then I genuinely would prefer if this ends up being a little more question oriented. Is that working? Is this up?
Yes, we can see it.
Okay, great. So this was a little bit, Summit Properties. So on the left here is 94 units that we delivered in 2023 in South Burlington. That's Kennedy Drive in the background. 71 of these had a low-income housing tax credit restriction on them. 23 were market rate. This, at the time, I think still was the largest sort of one-time delivery of affordable housing in the state of Vermont. On the right is a picture from the fall sometime, late summer, early fall, of Stonecrop Meadows in Middlebury, and I'll focus on that a little bit more in a second. This is a master planned community, new neighborhood construction in a designated zone. Uh, um, Took true partnership from the town, the state, uh, funding partners, and this again is a bit of a unicorn right now in the state of Vermont because of its size and being outside of Chittenden County. Uh, so this is a site plan. Again, we went through preliminary on 250 homes. We went to final plat on 184 homes, and we're under construction on the first 80. And what I'll show you, if you could, I don't know if you can see my cursor, but the stick-built building in the background here is the low-income housing tax credit building. That'll be ready in May. At the time of this picture, this first six townhome stick was occupied. 5 of those were sold to people through the Middle Income Homeownership Program, formerly the Missing Middle program with VHFA. And then you see the foundations going in up along the front, and then there are 2 more going in here and here. Those are all modular construction with Huntington Homes in East Montpelier, just around the corner from you all. Townhomes, most of which are being sold through the Middle Income Homeownership Program with VHFA. So the first 80 homes are really focused on, the affordable and the mixed income component. what made this neighborhood work so well was, the ARPA funding that came through 3 sessions ago, as you all were discussing some changes to Act 250. There was a bit of a compromise in the moment, which was they knew you all commissioned some reports and you knew you were going to be having a more robust Home Act or Act 181 conversation about Act 250. And so there were these 3-year exemptions for certain types of projects. We benefited from one of those. There used to be this for priority housing projects in designated areas. You're exempt from Act 250, but it used to have caps on the number of units based on the population of the town. So this project would have been capped at, I think at the time it was 50 or 75 units. But that one lifted that jurisdiction of Act 250 for priority housing projects, regardless of size. That is what allowed us to bypass, to not have Act 250 jurisdiction, which we can talk a little bit about, but was huge from a timing perspective, cost perspective, and as I know Kathy mentioned on Wednesday, it's really about the risk perspective, the risk of appeal. Allowed us to move forward. This is true smart growth. It's walkable to downtown Middlebury, energy efficient. I mean, these are great homes. The low-income housing tax credit building is geothermal, heating and cooling. Everything else is all electric. You can see on the site, the site is ringed with wetlands, and the 50-foot buffer here you see designated. We can talk about the governor's executive order if you guys are interested. I don't know if there's much legislative work on that right now, but we can talk about some of that. And again, this is sort of what these first 80 homes that we're under construction on look like. 28, big A affordable rentals, 31 middle income home ownership, 6 more deeply affordable home ownership, and then a handful each from the home ownership and the rental of market rate units. I will pause as promised there, only to say if I do want this to be question based, I have a couple things that I've been talking about as we've sort of tried to summarize what the last 2 or 3 years have meant, but I want to stop at least first, see if anybody has any questions about the project or, yeah.
Yes, we have a question, go ahead.
How, how high did you go with those buildings?
Why did we go with the types of structures or the
How
modular?
high did you go? How many
height.
floors? I couldn't tell from the slide on the right.
How tall are they?
Five, 3 stories.
Oh, got you. The multifamily building is 3 stories with a pitched roof. The townhomes and duplexes are all 2 stories with either a tuck under garage or a surface level garage.
And just so I understand, why did you not go higher?
Well, on the townhome structures, the amount of square footage we were shooting for, both for the market and the construction method, didn't need a 3rd story, right? So for the for sale product, the honest answer on the low-income housing tax credit building, the multifamily building, when you size those, the first, and this gets wonky, but the first limitation you have is the number of affordable units you can put in one of those buildings. There's a max award size. We have a certain allocation of tax credits. VHFA and its QAP puts a certain max, no single project can get more than 30% of any year's allocations. When you back into how many units that supports, it's going to be a certain number of units, usually in the 20s. And then typically those projects only have about 20% of them that are market rate units. So you sort of back into the number of units you need. We would not have been able to probably support the absorption of more market rate rentals, which gets into another point I'd love to talk with you all about if you're interested, but we just wouldn't have been able to support absorption of that many units because we were sort of capped at the number of big A affordable units.
So what does that mean, the absorption? Why couldn't you have done, this is, I want to understand it, so I'm not asking.
Yeah.
Why could you not have done in that building another 20 units of market rate housing?
Yeah, and I did when I listened to some of your testimony, and I apologize, I can't remember who of you it was, wanted to talk a little bit about construction costs. The really short answer is it costs more to build today than the market will support. And again, I've got some good visuals on that since you want to go down this path, I really want to make sure that we talk about. The short answer is like the tension always here is construction costs and incomes, right? And so it is so true that there are so many people that want housing and need housing, and we need to grow, but we developers simply can't build homes at a price point those people that are looking for homes can afford, which is why, as a state, what we're building are subsidized, affordable homes and higher end homes, because those homes that are getting built without subsidy are getting built to serve incomes that can afford what we can build today, right? I mean, does that make sense?
Yeah, and just one more that I'll.
Yes.
If that's the case, why did you build any market rate?
Because we were philosophically, we have a commitment to making sure we're not packing affordable housing into certain buildings. Every time we build, with big A subsidy, it is really important to us that there is a certain amount of mixed income nature into that. I think philosophically, it's important for affordable housing developers. I think it's important for the state. The QAP incentivizes it, right? And so we always try to incorporate as much of market rate housing into that as we possibly can. If we had put another floor that was all market rate, I don't think we would have gotten the rent we needed nor absorbed those quickly enough. I think we would have seen some vacancy, right? When I say absorb, I mean rent them up really quickly, or in a home ownership context, selling them. So, um, yeah, I don't think there was enough demand at the price point that we would have had to charge to support the cost of building another floor.
Thanks, that's helpful, I just wanted to really understand what the market.
Good. Thanks. I have a few questions. This is Ruth Hardy. First of all, thank you so much for all your work in Middlebury. It's
Yeah, thank you,
exciting.
Senator Hardy.
Unicorn project. Just to follow up on Senator Baumgart's question, if the VHFA subsidy was essentially capping you at the number of units you could build, if you had more money from them, would you have been able to build more, or was there other reasons why you couldn't build more affordable housing?
The only limiting factor to affordable housing, probably in the country, but certainly in Vermont, is scarcity of resources, is the amount of subsidy, is available. We had a market study. When we did our market study on this, oh gosh, I want to make sure I get these numbers right. We were talking about bringing 35 units right to the market, 28 of those being big A affordable. And we had a market study that said Addison County needed 1,500 new rental homes, and like 11 or 1,200 of those needed to be at an AMI at an affordable rate that was below a certain point. And so we felt that was sort of disheartening in that what we were doing was suddenly seemed such like a drop in the bucket. But I think the point is, when we talk about like nobody can find a home to live in, right? Nobody can find a home to live in that costs less than $3,000 a month to rent. If you want something that costs over $3,000 a month to rent, it's out there. Or if you want to custom build your own home, it's out there. But the conversation about affordable housing is just there's just not enough money, especially in a post-ARPA world, to build the number of units that there's demand for.
Yeah, and I know that down the hall, they're trying to tackle that issue of how do we get more funding to subsidize affordable housing. So hopefully they'll have you in down there. But my other two questions was, one, I would like to hear your thoughts on the wetlands issue, because that is an issue that is percolating in various places. And then also one thing that in addition to all the housing we need, one type of housing that we really need is sort of specialized supported housing. And I heard a rumor, and I don't know if this is true, that you were trying to work with some people who are looking at specific housing for people like adults with disabilities or something like that. And I'm wondering if that has come through, and if it has, how did that happen? If it hasn't, what were the barriers to that?
Yeah, well, I'll come back to the share here. Go back to this picture and start with the wetlands piece. So I think I can see in the, let me know when this comes up. Yeah. So again, this is the site. This is an aerial shot of the site of Stonecrop Meadows. It's somewhat, this is at an angle, obviously, and this is the vertical, but you can sort of see this wetland line with the buffer. What you see in the background here, uh, and again, can you see my cursor as I go over?
Yeah.
Yeah, so this black line here is a silt fence, and that black line is installed at the 50-foot wetland buffer. And then sort of what you see past the old hayfield is the wetland, right? So this is all delineated wetland all around. And this silt fence is your 50-foot buffer. And so that's sort of what a 50-foot buffer looks like in practice. This here is a stormwater pond. There will be a stormwater pond here, and there'll be a stormwater pond here, all inside of the wetland buffers. Essentially, what that does, the size of the buffer. So a couple things, and I'm not an ecologist, and so I know that I'm not. I'm giving you the developer's perspective, right? We need to build these stormwater uh, ponds to release in a 100-year storm water into the wetland at no greater a pace than the unimproved lot does, right? And I think there are probably engineers that'll quibble with exactly how I said that, but the point is we can't make it so that water dumps into the wetland faster. The way we do that is we take all of the stormwater that collects, you put them into catch basins and you pipe them into these stormwater treatment ponds. And then those can collect it for a little while and then release it at a slower rate into the wetland. This site is, classic Vermont Vergennes clay that does not, once it's absorbed, it's running water and then there's ledge underneath. And so already the site condition was that it goes into this wetland really quickly. What happens is, we have to then build, and so here's that buffer line, that 50-foot buffer line. We have to design this site. This is a perfect site right up until that. If we had been able to go to a point that was halfway in between this, 25 feet, we would have been able to get more units on the site. We would have had to design bigger stormwater treatment because now we're going to have a little bit more impermeable surface. But again, that stormwater treatment is getting designed to not discharge water any faster to the wetland than it already is. And so I think when we talk about the trade-offs between, how big of a buffer we might want versus what the limitations are, and we think about not wanting to, to really focus development in our core centers, it's just, that trade-off understanding. If we'd had another 25 feet along what is, I think, about half a mile worth of border here, 4/10 of a mile, that would have been some developable acreage that we could have used to add units, add efficiency, and reduce cost to hit a lower price point on each of these and open it up to a bigger piece of the market. Now, that's not an ecological argument. That is just sort of as we think about why those matter. That's where that comes in.
Okay, are you doing that, if you go back to the map that you just were at, the sort of spur that goes off and there's a circle to the upper right, is that happening, that part of the project?
So what we have preliminary plat approval for is this part, right?
Okay.
In order to do this, we would need a wetland impact to cross the wetland right here.
Yeah,
And this we sort of have been picking as setting aside as an independent senior living project, larger building, having the amenities. It's a part of what we do. So we are not to final plat on that. We have final plat approval on all of this.
got it.
I don't know. I hope we get there. We'll need to talk about the wetland impact, but in conversations with the state wetland ecologists, being able to deliver, 70 units of housing is worthwhile for the impact of the culvert that would be required here at the narrowest point of the wetland.
Got it, okay. And what about the other thing?
That's a great question. We've been talking with a group of families in Addison County that have children with intellectual and developmental disabilities. It is in some ways no easier a nut to crack than any other vulnerable population, like a low-income population or a homeless population, in that it is about how you operate and sustain the debt service and get built. And so it all comes back to cost. The design, even the services, right? With CSAC, they're like, we can provide these services. We just can't be landowners and we don't have the money to to build, own, and maintain. And so what can you as developer do? And it always comes back to like, well, how are we going to finance this? And it comes back to scarcity of resources, and it comes back to, we just can't build at a price anymore that can support the type of, vulnerable populations without a lot of subsidy or a lot of state support, right? And so it's the same quagmire that we are not quagmire, but it's the same challenge that we end up in no matter what population we're trying to serve. Still talking to them. I hope there's a place on this site that we can put something together, but uh, again, it's the same sort of troubleshooting on how it's financed and operated.
Okay, thank you, that's helpful.
Yeah, yeah.
Yes, good.
Actually, just to follow up on that, are the subsidies the same?
Well, no, and as far as okay, big step back. There is a huge industry of affordable housing. It's a federal program, the low income housing tax credit program, so when
Yeah.
you've got expertise in the low income housing tax credit program, it makes affordable housing really easy. That we've got VHCB, we've got VHFA, we've got DHCD. There's a lot of entities, money, energy, organization around how we build those projects, right? There isn't the same attention to vulnerable populations like people with intellectual or developmental disabilities. I know VHFA and VHCB are trying to talk about whether some of their funding can be used towards those, if the Vermont State Housing Authority can have vouchers that support those. But right now, there just isn't, we're focused on low income and formerly homeless or currently homeless. We're not focused with them as a category of vulnerable populations that we're actively subsidizing.
So there's not a similar, at the federal level, there's not the equivalent of LIHTC we're building.
I'm sure there are programs, but certainly nothing that to that level, right?
Okay.
And nothing that we have expertise or knowledge in. But that's one of the benefits that those families are bringing, right? They're really doing that research and trying to understand that and bringing that to us, and that's a piece of.
So to the extent we want to do this, can it's the road that Senator Hardy is going down is a road we need to really explore. We're gonna have to do a lot of it. We have to figure it out at the state level.
Yeah, that is my understanding. I'm in no ways an expert about that.
Yeah.
Yeah.
And there've been a couple bills on it in the last few years, studies and various things, but this is a huge issue for people around the state. Yeah.
I prepared a couple of slides, not knowing exactly where your attention wanted to go or what I can do. Senator Bongartz, you brought up sort of, how well, we kind of got to the point of how cost is driving. Why aren't we building more affordable housing? I have a couple, we've been thinking for so much as we come in and testify over the last 3 years of how do we make this as simple and understandable as possible and really express it. Hopefully, I'll share a few more slides and that can be a conversation starter and stop me at any point if, my attempt at simplicity is just leading to people glossing over before lunch on a Friday. I think as we about to hit 11 o'clock, I heard at one point, like the worst time to be sentenced by a judge is between 11 and noon because they're the crankiest before lunch. And so I know we're entering that 11 o'clock hour, especially on a Friday. And so, at any point, this is not interesting to you. Just tell me and ask me an irrelevant question. But
It's all interesting, so no worries about it.
all right, good. It's interesting to me, but I don't want to take that for granted. So you guys have heard a lot about we need 30 to 40,000 new homes, right? I assume that's not a new number. People have heard it's been out the last few years with DHCD and VHFA's housing needs assessment. 41,000 is the number they say we need to hit our 2030 demographic goals, economic development goals, vacancy rate for the housing that's needed. And they do this dashboard that says we're on pace to build 12,000. And one of the reactions was what one of you said, I often get is like, well, why aren't we building more affordable housing? Between Kathy and me and my team, we build, 80 to 90% of the affordable housing in the state of Vermont every year. And it's, there aren't enough developers and there's not enough resources to support those developers. We're probably on pace to build 1,200 units of affordable housing as a state in the next 5 years. And that's just because of scarce resources. The point here is we're not going to solve the crisis by building more big A subsidized affordable housing. This green here kind of represents the rest of what we're on pace towards, the 12,000, right? 11,000 of that or so is what the market is supporting. Custom homes, higher end rentals, the stuff I talked about at the beginning that that people can afford based on what it costs us to build it, right? We're builders, developers, not us, but developers around the state are catering to that clientele because that's the only people that can afford the products that can be built with today's construction costs, labor costs, land costs, whatever you want to call it. So that really like leaves us in yellow here, this 20 to $30,000, 20 to 30,000 homes that we need to find a market solution for. Like we need to figure out how homes can be built and what that kind of ends up looking like in who can buy it. And this is where it gets a little wonky, but bear with me. The lighter green line is the number of households that make these incomes. The lighter green line is Chittenden County. The lower green line is Addison County. And I picked those two because we're working in Addison and Chittenden counties, so we're most familiar with them. In 2020, we could build a home for $300,000. And that was affordable to people that make, between at some point between $75,000 and $100,000, but think about it as $100,000 and up. In 2025, that same home is costing us $525,000 to build, and incomes just haven't accelerated at that same pace. And so you need to make 150 to 200, but probably more than $200,000 to afford it. And so the green on the right are the households that can afford new construction. And the households in yellow are the households that maybe could have 5 years ago and can't anymore. And so this is like the visual representation of when we make if we make homes expensive, who we exclude from the market. I'll pause if somebody has a question.
I do have a question, so I want to make sure that I'm understanding this graph.
Yep.
So, okay, the people in the yellow in between, this is those are the people who can no longer afford the same house.
Yep.
That's an accurate way to?
Yeah. And this is the peak of the bell curve of incomes, right? This is a moderate income, median income, to above, but a pool of home buyers that are the greatest sort of concentration of incomes.
Okay, and okay, so we're really looking at the the curved line is effectively like the number of households that earn that income.
Yeah, correct.
So, okay, I think I'm digesting this now. And so, okay, so it's basically, it's a picture of who can afford what overlaid onto the effectively like a histogram of incomes.
Yeah, and
Okay.
another way to look at it is, this home that we can build for 525 in 2025. If you're right of this line, you can afford to buy it. If you're left of the line, you can't.
And this is for market rate housing? No,
yeah, correct. Yeah, unsubsidized. This is just now I'm pivoting away from anything with a big A affordable subsidy because that's such a small sliver of our overall need. Yeah. Another way to look at it is to sort of put these two together, right? So with this red line from that first graph I showed up here, right? This was my sort of way to show you this DHCD dashboard, which is affordable housing being built, higher end housing being built, the housing that's not being built because there's no market for it, right? So you put those two together and basically this line is the same as this line, right? This is to the left of this line is the people that are not being served. Above this line is a representation of not being served. And so what we think about as developers is, okay, what can we build it for? And how many people are there that can buy that? And so we think of every policy decision you all make. We think of every, change in incomes, every change in interest rates as essentially, who's going to be able to afford this home? Like what finishings are we going to have? Are we going to have a back deck? What kind of parking is there going to be, right? And so we think first about what do we think it's going to cost, and policy drives that, and then who can afford that. And so when we think about solutions to how do we create a market for this, we start to say like, okay, if you can make something that takes the cost of this home from $525,000 to $500,000, you're moving left on this line of the number of people that can afford it, and it opens up this amount of the market. the homes that we can build. And so now we as developers can build homes that this portion of the market can afford. And as you keep moving left, right, it sort of exponentially grows as you get to the higher part of this. And so, okay, what are the levers to go from $525,000 to unit to $450,000 a unit? Because this is the population of Vermont that you start opening up to be able to afford a home, and then you'd be able to open up developers to build homes. That's the sort of like oversimplified underlying aspect. And so we start to say, okay, how can we build more cheaply? We're trying to do working with Huntington Homes to see what modular can save us, right? Modular is saving us about 6% on the cost of the home. So you're not getting from 525 to 500, but you're starting to eke that way. And this is where it starts to be conversations about the stuff that we talk about there being political will for. If you can save costs in Act 250, if you can save costs, this goes back to the other piece that's been controversial in the governor's executive order, which is going from the 2020 RBES, the energy standard, going from the 2024 to the 2020. A lot of builders have said that costs about $15,000 to $25,000 per unit. And so when you do that, essentially what you're doing is you're making a tighter home, you're making it more energy efficient, but you're moving this line to the right on who can afford it. And so there are some policy trade-offs we start to make. And the biggest thing, because we always come in and say, we are all for energy efficiency. We're all for the tightest envelope we can possibly build. But as soon as we make those changes overnight, we are just pricing out a certain portion. And then we get the argument back, yeah, but the long-term savings of the energy efficiency is worthwhile. And it's like, yeah, but that doesn't get underwritten by a mortgage lender. So those buyers do get cut out. And so some of this is like if interest rates came down, you would immediately the purchasing power of people at certain incomes would go up, and you'd immediately have a greater market for homes, and we could immediately build more homes. We don't control that. We really only control the policy decisions that we make as a state. And this is kind of what that looks like as those slide on cost. I'm going to pause. That is like my wonky developer perspective on, supply, demand, how we create a market for more homes here in Vermont.
No, that's great. I think that's very interesting. I really appreciate the visual there. It's very helpful. Yes.
Yeah, Zeke, that's really helpful to see those visuals. I agree. And the oversimplification of it is helpful for us who are trying to absorb a ton of information every day. And I know you're in the business of more large scale development. That's kind of your MO, I think, right? Yeah, that's what you do. So so I don't know if you'll know the answer to this, but is part of moving the line to the left doing like refurbishing the housing stock that we have to make it more match what Vermonters need? Does that help move the line to the left? Like the big farmhouses making those 4-unit condos or whatever, or 4-unit apartments. Or infill building of 1 or 2 houses in, places in our towns or something. Does that move the line to the left or not?
Yes, there is like an all hands on deck. We need every solution. Some people say like, don't worry about ADUs because ADUs aren't going to solve the issue. That's true, but like no one thing is going to solve the issue. So if we can convert, 4 or 5 bedroom Victorians into 2 or 3 condos, you're adding to the housing stock without adding impermeable surface. The cost is still real, right? Sometimes the price per square foot to renovate an old building is no less expensive than the price per square foot to build new on a greenfield site, right?
Okay.
But that isn't to say one is better than the other, right? I mean, my whole point in all of this is like, yes, it's a yes and moment. So if you start to look at it as what would be a more efficient use of scarce resources, that ends up being sort of a case by case basis, and it depends on the condition of that farmhouse, and that just becomes more of a nuanced conversation. Not projects we do. You heard Kathy, I think on Wednesday, talk a little bit about why some of their costs are higher. Yes, dense infill in existing centers is more expensive. Brownfield remediation is more expensive. What we did in Middlebury was a hayfield, true greenfield development walking distance to downtown, and that exists in a lot of towns. And I know that I mean, I'll say controversial, right? Everybody hates to see a hayfield go away, and I understand that. Um, but we need to be okay with trying to find the most efficient places within the parameters of our dense downtowns, um, surrounded by countryside. And we just need to be as inclusive of that type of development as possible.
Yeah, and the hayfield that you built on was the perfect hayfield to build on based on where it was. I mean, it's a completely logical.
Yeah.
And I asked you in last year, I think maybe about the sidewalks, and I see the sidewalks are in, so yay.
Yeah. No, the pedestrian connectivity is great. I think, I'm jumping around, so you can all rein me in anytime you want. But one of the big takeaways, and this is sort of what I was asked to originally talk about from the last 3 years worth of legislative changes on Act 250, on, as we enter this tier one A and B era, like those were huge efforts. And my genuine concern, and this in no way diminishes the work, but my genuine concern is that, we didn't go far enough to try to have the impact we really want to have. And I understand there's political will and there are, a lot of interests at play. But from a developer's perspective, if I look at how that 1B map is going to end up, how that 1A map is going to end up, there aren't so many available parcels that have removed some of the jurisdictional and permitting challenges that we're going to suddenly be able to go from 2,500 new dwellings a year to 8,000 new dwellings a year, right? It's good progress, and I'll echo Kathy in saying, really big wins that we have to celebrate. But we do have to collectively push our comfort zone if we're going to try to tackle the demographic and economic development and housing crisis. The response we gave was, it would be really nice to have more homes. The reaction wasn't, oh my God, we're in a housing crisis, here's our solution, right? And so I think I say that both to celebrate what we were able to accomplish, but also say there's more work to be done, and hopefully there's continued political will to see the challenge.
Volunteer, yes.
So just thinking along those lines, the reason I was asking about height a little while ago is it less expensive or more expensive or equal to build 2 5-story buildings as opposed to 1 10-story building? I mean, is up part of the answer here?
Yes, and it depends on where and what that looks like. So the least expensive per square foot construction is probably a 2 or 3-story slab on grade, no elevator, right? Elevator adds a huge wrinkle because of the cost and the number of units you need to support. You can build with wood 4 stories. Once you hit 5 stories, you need to start building with steel. And that adds a ton of cost per floor. And so it doesn't really make sense to build 5 and 6 stories with steel, because once you make the switch to steel, you really need to get to that 7th or 8th story to start making it pay off, right? And so and you're going to have an elevator once you get to 3, 4 stories, no matter what. And so as we think of, and that's sort of, such an interesting moment we're in trying to figure this out. And I keep going back to my slide deck here, but as we think about this site, we're building out everything that's kind of in this right now. And we've got these structures permitted, and this structure, which is a 4-story, 48-unit building, permitted. But we're trying to figure out construction cost based on our understanding of what the market can afford right now. And so, would these be good as a 2-story slab on grade, walk up, no elevator, very simple, surface parked? Would the market be able to afford a home like that? And what would condos in a 4-story up to 50-unit building look like here? I mean, since we have this through final plat and we're trying to bring as many units to Addison County as we possibly can, we're running all those numbers right now. And it's sort of a fun playground only because it's the same site, same infrastructure costs. it's permitted and we can run it with as few variables as possible. So that was a really long way, Senator Bongartz, to answer the question of, yeah, there's efficiency up, but once you need to do an elevator, you need to do enough floors and enough units to get that elevator. And once you go to 5 stories and start doing steel, you need to get enough stories to be able to pay off, to be able to make that change worthwhile.
So I mean, if you go 4 stories is one break point. And the next time, if you're gonna make any money, you gotta go 8 or 9.
Yeah, and again, we've never done anything more than 4. So there are developers that have, and they may have better numbers on that. So I wouldn't want to be
That's fine.
on the record representing for the development community that 8 or 9 is necessary. But yeah, I mean, our buildings in South Burlington, doing this to you all, toggling back and forth, but these are 4-story on a concrete podium over a parking garage, wood construction. If we'd gone a 5th story on these, which the South Burlington market could have supported, probably, we would have had to go to steel construction, and it would have become prohibitively expensive just to do 5 stories. Yeah.
It's interesting to get some sense of the breakpoints.
Yeah.
So thanks.
Elevators are really hard.
Yeah.
Elevators add a huge wrinkle.
Elevators and steel.
Elevators and steel. Yeah, but yes, going to 5 stories, there are only so many places. Elevators in any building end up being a big challenge.
Okay, yeah.
So that's interesting. I mean, I think of you all as one of a developer that does large buildings. If you're not doing steel, does anybody in the state do steel?
Yeah, I mean, what you see going up in Burlington, right, those are all steel framed buildings, stuff that, gosh, where would be, can I think of a 5-story steel building outside of Chittenden County?
Yeah.
Nothing obvious in the last 5 years. Somebody's going to correct me on that if anybody's listening. But no, what you see going up in Burlington, right? If you've been downtown, you can see that steel frame. I think some of the stuff at Campbell Rise. Yeah.
Okay.
Interesting. Okay. Thank you. Any other questions? Thank you. This has been very interesting and helpful. So really appreciate your testimony, and to be continued.
Here for any follow-up, whatever I can do to help.
All right. Thank you.
Appreciate you all. Thanks.
All right. Any comments folks would like to make before we close for the day?
Comments on
On anything we've heard today. Okay. Okay, fair enough. Super. All right, to be continued.